Part 3 of the EA exam is where the IRS gets real. It tests ethics, laws, and the rules that govern tax practice. Think, who can represent taxpayers, what standards you must follow, and what happens when practitioners mess up. On the EA exam, they love questions that feel like workplace policy, but the source is federal authority, not your firm's handbook. Prometric breaks Part 3 into 4 buckets, and the exam writers stick to them. Practices and procedures is the biggest slice. Representation before the IRS is close behind. Then you get specific areas of representation, and finally, the filing process. Exam tip: if a question is about, can this person appear for the taxpayer? That's representation. If it's about how the IRS moves a case through audit or collection, that's practices and procedures. Ethics and practice standards live in Treasury Department Circular 230. If you represent taxpayers before the IRS, Circular 230 applies to you. That includes enrolled agents, CPAs, attorneys, and others authorized to practice. The IRS Office of Professional Responsibility, OPR, enforces it. On the EA exam, watch the wording. Discipline like censure, suspension, or disbarment changes what you're allowed to do. Now zoom out to tax law. The Internal Revenue Code is the main body of federal tax law enacted by Congress. It's published as Title 26 of the U.S. Code. But not all tax-related rules are in Title 26. A classic exam trap is international reporting. FBR rules come from the Bank Secrecy Act under Title 31, even though the IRS helps enforce it. Here's the weird but testable part. FBAR enforcement was delegated to the IRS by FinCEN. FinCEN is part of Treasury, and it administers the Bank Secrecy Act. So you might file something with the IRS, but the legal authority is still Title 31, not the IRC. On the EA exam, separate who enforces from what law created the rule. Finally, federal versus state law. The EA exam is testing federal law, IRS authority, and federal rules. But state law can matter when it changes what gets reported federally. The big example is community property. State community property rules can change how spouses split income on separate federal returns. So the exam isn't testing state statutes for their own sake, it's testing the federal reporting result. Which of the following disciplined practitioners may represent clients before the IRS? The choices include a practitioner who has been disbarred, a practitioner who has been publicly censured by OPR, a practitioner suspended from practice for 2 years, or the option that none of them may practice before the IRS. Think about it. The correct answer is the practitioner who has been publicly censured by OPR. A public censure is essentially a reprimand, and by itself, it doesn't prohibit practice before the IRS. The tempting wrong choice is none of them, because disbarment and suspension do block practice, but censure alone doesn't. Which of the following is an offense that could lead to practitioner sanctions by the OPR, according to Circular 230? The options are gross negligence, gross incompetence, gross delinquency, or gross recklessness. Think about which phrase Circular 230 actually uses. The correct answer is gross incompetence. Circular 230 allows OPR to censure, suspend, or disbar practitioners for incompetence and disreputable conduct, and gross incompetence is a recognized basis for sanctions. A tempting wrong answer is gross negligence because it sounds legal, but it's not the Circular 230 phrasing they're testing.